Okay, so I think we're just going to start. We want to get you out of here on time so that you can go and have lunch. I'm sure you're hungry after hearing about all of these different topics. Again,
Or
I'm Liz
perhaps not.
Deckman. Yeah, I'm Liz Deckman. I'm in the Seattle office of Dorsey and Whitney. I'm an employee benefits attorney.
And I'm Rebecca Bernhard, and I am in the Labor and Employment Group here in Minneapolis.
And I specifically wanted Rebecca to be on this talk with me because when I deal with severance arrangements, I'm always amazed at how many different types of rules apply to severance, not just ERISA, but there's discrimination rules, there's state laws, there's just so many different things. And so I thought this would be a good topic to end up with today. And we want to give you 5 tips. There's a lot underneath each of those tips, but 5 tips for you to think about when you're looking at your severance arrangements. So tip number 1, and this is one that's near and dear to my heart, think about whether or not your severance arrangement should be an ERISA plan. Now, we just heard Bob and Andrew talk a lot about ERISA claims, ERISA plan documents, and it really is sort of a very important part of looking at a severance arrangement. Sometimes I'll have an employer come to me and say, well, this is my severance, and it's on a piece of paper, and that's fine, but I would really urge you to think about whether or not you want to go to the step of making that arrangement an ERISA severance plan. That's because ERISA preempts state law in several respects, especially the claims procedure that we were just talking about. If a lawsuit is filed, it has to be filed in a federal court, and you'll have a judge, not a jury, generally looking at those particular claims. And any claim decision made by the plan administrator is going to be given a lot of deference in court. It's going to be an arbitrary and capricious standard and not a de novo standard, meaning that the judge will not look at fact 1 and go through the whole scenario to determine whether or not the plan administrator's decision was correct. The decision will be given a lot of deference.
So just to piggyback on that, for those of you who understand both employment and employee benefits law, having ERISA preempt all of the myriad state law claims that arise in termination situations can be a nice benefit to the termination situation. So we often cooperate with our benefits colleagues in advising our clients to have standing ERISA severance plans for that very preemption reason.
So there are some prices, though, to be paid if you are going to be an ERISA plan. Bob and Andrew talked about having to have a plan document. You also have to file a Form 5500 if you have at least 100 participants participating in this plan. And what's interesting, and this is what I see some confusion, and I guess there's maybe a difference of opinion sometimes about how to count those participants for a severance plan. The conservative way of looking at that is not to say, okay, we had 100 people get severance benefits this year, therefore we have to file a 5500. The conservative way of looking at it is to say we have 100 people who are potentially eligible to get severance this year, and therefore we have to file a 5500. What a lot of employers I see doing now, and this is what we suggest doing, is wrapping a severance plan into your health and welfare plan so that you will have, your medical, dental, vision, LTD, STD, life, and a severance component all within one plan document. So you satisfy the plan document requirement, and you only have to file one 5500 if you're subject to those rules. And of course, you need to get an SPD that has all of the special ERISA language that needs to go into an SPD. But you also have to make sure that your plan qualifies as an ERISA severance plan, not just as a payroll practice. And what the courts have said is that you need an ongoing administrative scheme for those severance arrangements to become an ERISA severance plan. And there's no hard and fast rule that you need to look at to determine whether or not your arrangement is a plan or not. But here are a couple of things that we've seen. Do you only pay a lump sum, or do you pay a series of periodic payments? Now, just because you pay a lump sum doesn't mean you're not an ERISA plan, but that's just something to think about. Is there a case-by-case analysis to determine eligibility for benefits? If you say everybody who is an employee who gets terminated involuntarily gets $5,000, that may be a payroll practice, but if you say, okay, it's these people, you have to have this amount of service or be at this pay level, those people are eligible. Or if the benefits are every person gets X number of dollars times your years of service. That requires somebody to look at individuals and find out what their years of service were and come up with a benefit amount for them.
So I'm going to ask a question. Even though there's not very much discretion in that formula, there is administration. So is the discretion administration kind of a, they work together?
work
You can have a lot
together.
of administration even if there's not very much discretion?
Right. And I think that it is important, as the last bullet point, do managers have discretion in administering the plan, not only for purposes of the standard of review that you get under the standards that Andrew was talking about, but also, we have discretion in determining if you are eligible, if you're not eligible, what your benefit is. Obviously, the less discretion and administration that's necessary to implement the arrangement, the more likely you have a payroll practice and not an ERISA plan. Okay, tip number 2, and this is one that's sort of esoteric, but it's still important to know. Don't make your ERISA or your severance arrangement an ERISA retirement plan. Well, how can that happen? I mean, you're giving severance benefits, right? Well, under the Department of Labor regulations, there are 3 prongs that if you satisfy them, your severance arrangement may actually be an ERISA retirement plan. And you don't want that to happen. Anybody here who deals with a 401k plan or participates in a 401k plan knows that there are discrimination rules, there are coverage rules, there are vesting rules, things like that that you don't want to have applied to your severance plan. You want to be able to have flexibility to change your plans. So what are the 3 prongs that you have to watch out for? Your benefits can't be contingent directly or indirectly upon an employee retiring, i.e. saying anybody who is age 55 and has 10 years of service get this benefit. The total amount of payments can't exceed 2 times the employee's annual compensation. And unless you have some sort of a special window benefit, all payments to the employee have to be completed within 24 months of termination of employment. Now, you'll see this 2 times pay and 2 times, the payment period, 2-year payment period, that's going to come up a little bit later. But most severance plans that I've seen don't fall within these requirements, but just think about it when you're trying to figure out what you're going to be, how you're going to be structuring your severance plans. Okay, tip number 3. We could go on for a very long time about Section 409A of the Internal Revenue Code. And I think sometimes people are surprised that severance plans can actually be subject to 409A. This section of the Internal Revenue Code deals with deferred compensation. And basically, what it says is that any time that you earn a right to compensation that's paid in the later year, there are lots of rules under 409A that apply to those payments. For example, the form of payment has to be stipulated, when it's paid, those kinds of things. And it's not that you shouldn't or can't be subject to 409A. It's not illegal to be subject to 409A. It's just that if you are and you make a mistake, there are a lot of tax penalties that the employee who's getting the severance payment that's a failed 409A payment will have to pay. And nobody wants their executives to be unhappy. Nobody wants their former employees to be unhappy. And so it's important sometimes to think about whether or not you want your plan or your arrangement to be exempt from this section. So there are a multitude of rules under 409A. I could talk for a long time about them, but I'm not going to. I'm going to talk about 2 that I see most that come up in the severance arrangement sphere, and that is the short-term deferral and the 2 times 2 exception. So under the short-term deferral rule, it says basically that if you earn a right to a severance benefit and it's paid shortly after your termination of employment, then you're not going to be subject to 409A. Generally speaking, it's within 2.5 months after termination of employment, but that can spill over into March 15th of the following year. So oftentimes I will see employers say, okay, all severance benefits were going to be paid, within 90 days of termination of employment or after you sign a release. The 2x2 exception allows you to make payments over a period of time. And this is sort of, I was telling you about the ERISA retirement plan rules. Well, this is sort of a twist on that, because of course they can't be the same. So you can have ERISA severance benefit payments that are paid over a 2-year period after termination of employment or separation from service, which is the technical term under 409A. But the amounts can't be more than twice the employee's pay or the qualified plan comp limits, which is $270 this year, whichever is less. And I think 270 times 2, I'm not great at math, but I think that's $540.
I think that is.
So if you're not paying more than $540,000 over a 2-year period, then you will be exempt from 409A. One thing to think about, though, is that these terminations have to be either an involuntary termination of employment or that the employee can only earn these benefits if they have a good reason for terminating employment. And that means that there's a material diminution in their authority, their responsibility, the number of employees they look out, that they supervise, the budget that they're in charge of, or maybe you've moved them halfway across the country. It can't be, I've had a bad hair day and I'm quitting. That would not be sufficient. There's also a way to stack some of these exemptions under 409A, which is getting into a lot of complications, but needless to say, these are the 2 that I see most often. A tip, like tip 3B, might be look out for paying continued medical coverage over a period of time. I always say no good deed goes unpunished, and I have seen where employers have agreed to pay somebody's COBRA premiums, or say we're going to pay you, reimburse you to go out and get medical coverage. Under 409A, amounts that are not taxable are not subject to these rules. So if you have an insured plan and you're giving, at least currently under the current rules, if you have an insured plan and you're paying people's medical coverage on a continued basis, you're not going to have a 409A issue. But if you have a self-insured plan and you're only paying for the top execs or the top employees to be getting this continued coverage, that coverage may be taxable to them. And therefore, after the first 18 months of COBRA coverage, if you're still paying them, that amount is taxable and they will be subject to 409A. There's also an issue about whether or not if you say, I'm going to give you money to go out and buy your coverage someplace else, whether or not you have failed the market reform provisions of healthcare reform, because you're really not giving them benefits, you're just giving them money. And that isn't going to be giving you, the employee or the former employee, the right kinds of benefits. So what do we suggest doing? To me, I like easy things. So what I've often said is figure out how much you want to give them for medical coverage and say, when you terminate employment, within your severance package, here's X number of dollars. We'd like you to use this money for medical coverage for you and your family, but you don't have to. It's your decision. That amount is going to be taxable, but it's paid immediately and you're done with it, and they can decide whether or not they want to go to the exchange, if they want to use that money for spouse coverage under the spouse's health plan. It takes you out of the equation, but it also gives them some cash to help them with their medical.
Does the taxable issue change if you're paying your TPA, the COBRA, you're paying the TPA directly for the COBRA coverage?
Maybe. But you still have...
I don't advise that, but people ask that all the time, so I just thought I'd ask you.
You will still have your 105H problem if you're a self-insured plan. But yes, I mean, also, the thing is that you have to be able to track that the money was used for some pre-tax purpose, like employer-provided medical coverage, until whatever happens with ACA reform. So if you can actually prove that you've paid for medical coverage, you will have a better chance of being able to show that that was on a pre-tax basis. And timing of releases. Now, I know Rebecca's going to talk about releases, but just to know that the timing of when somebody signs a release, they may be able to juggle whether or not it's going to be paid in 2017 or 2018. And that's a 409A problem. So you want to be able to make sure that your releases have some special language, like you have to have a fixed payment date that's within 90 days of whenever you sign the release or you terminate employment. And if that spans 2 years, you're going to pay it in the second year. That should be already baked into the release if you're going to have that kind of an issue. And then if the release isn't signed and timely returned, then they don't get the money. So that's another stick to make sure that they look at it and determine whether or not they want to be signing.
Does that apply if you're leaving on forming exceptions? That same thing will apply?
I think it does. I think you should try to have it in every release. Tip number 4, written severance provisions are important. And we just had a talk with Andrew and Bob talking about plan documents. And, it's sort of counterintuitive. You might think that the fact that there are few written plan document provisions in your severance arrangement, that's a good thing. Maybe, maybe not, because having no written plan can actually restrict the right for you to amend or terminate your plan, particularly if you have an ERISA plan. And there have been many cases that have held that informal severance arrangements that you've done over and over and over again to terminate employees, that gives rise to claims for similar benefit plans. And so you want to make sure that the plan administrator has discretion to make all eligibility and benefit determinations. And then you get the good standard of review. In fact, I don't know if anybody here looks at Benefits Link daily. I do. And there was just about a week or so ago a case out of New Jersey where this particular claim was made. Somebody said, you've been doing this over and over and over again, and so therefore I'm entitled to these benefits. Well, this probably wasn't a very good fact pattern because the employer did eventually prevail and said, no, this is just a payroll practice. We only give it out sporadically to people. But it would have been a lot better to have those things in writing and be able to prove to the participant or the employee, no, you're really not entitled to these benefits before they went to court. And here are a couple of things that you might want to put in your ERISA severance plan. A reasonable statute of limitations for filing a lawsuit. Specify which state's laws will govern the interpretation of the plan to the extent that it's not preempted by ERISA. Specify which court litigation can be brought in, and stipulate that claims and disputes are subject to arbitration after exhausting the claims procedures, if that's something that you're interested in.
Okay.
Very good.
So on the employment law side, we, in addition to liking to work with our benefits colleagues and having a nice written severance plan that we're working with, we also want to have a severance agreement that ties with that. And so we like the severance plan to say that the people must sign a release of claims to get that severance benefit, because in the employment law world, we want folks to be waiving their rights to sue under all of the alphabet soup employment laws that come up in the employment world. And so we want to be able to say, hey, you got these benefits, and in exchange for those benefits, you're agreeing not to sue us for all of the possible employment claims that may come up. And then we want to put all of that in a written agreement. And sometimes we have to tie all those things together. And if there are executives or other folks involved that have employment agreements, hopefully all of these documents tie together, hopefully, or if there's an offer letter and it says, welcome to this wonderful company, we hope you work here forever, but if you don't, here's all the benefits that you're subject to when you leave. And you have to sort of mirror and match and make sure all of those documents don't promise things or do promise the right things and tie back to all those benefits. So it's important when we're walking them out the door that this final document sets forth everything that they're entitled to and sort of ticks and ties up all of the benefits and also releases all the right claims. So we want to spell out sort of exactly what they're getting paid in terms of the actual benefits and refer them to the plan documents in terms of what it is they're entitled to. And we also want to make sure that we're keeping alive any other obligations that they have. For example, maybe they were bound by some non-compete or other types of intellectual property protection, confidentiality agreements that they signed at the front end of their employment, or maybe if they got promoted throughout their work history and maybe got subject to LTIP or other types of incentive programs, and that's where they got offered certain types of benefits, but in exchange for restrictive covenants like non-solicit, non-competes. You want to make sure that you're referencing that although they're separating and they're releasing claims, they're still bound by certain restrictive covenants. And so you want to make sure that your separation agreement spells out the money that they're getting, but also reminds them of any sort of post-employment obligations that they have, and doesn't kind of release them from those obligations. Unless, of course, that is part of the deal. Sometimes that's additional consideration. Sometimes the severance plan that they're subject to isn't enough to get them to sign a release, or maybe you didn't actually make them sign a release of claims in exchange for the severance plan that you offer, and so you're trying to get a fuller release, and so they're already entitled to 2 weeks of severance for every year of service, and you're trying to get a release of claims, so you can do something like waive some of their non-compete obligations in exchange for a release of claims. So that's some of the creative things you can put in that severance agreement to sort of tie all of that up. And so you want to make sure that's all spelled out in there. And then, of course, a full release, everything that you can release, except all the things that you can't release. You want to make sure that you're clear about that. It's real, as Andrew and Bob were talking about, ERISA types of claims are difficult to fully release in terms of vested benefits. So you want to make sure that in that alphabet soup of your release paragraphs, you've clearly carved out the types of benefits that can't be released, or else you're in danger of losing the full benefits of your release. And there's also certain other types of claims that can't be fully released. For example, you can release your discrimination claims, but the EEOC, and that's this next bullet point where I say severance agreement considerations, the EEOC has rules in which, although you can release a person's individual rights to recovery if they proceed through the EEOC, you can't release the EEOC's right to proceed on its own with a discrimination claim against you. So they have the right to participate, in an EEOC proceeding, but they've waived their right to individual recovery. So that's one of those tricky drafting things that you got to make sure you get right. Similarly, the SEC has now weighed into this concept of release of claims, and they don't want folks releasing their rights to whistleblower awards. So you got to make sure you've carved out an individual's right to cooperate with the SEC and to any rights to whistleblower awards. So, and they can't waive their rights, for example, to workers' compensation coverage for claims that have arisen. They can't waive their rights to unemployment. So there's a variety of vested benefits and certain types of statutory claims that the government has said, nope, people have the rights to. So you want to make sure you've got all that spelled out. And then some of the timing things that Liz alluded to that I was going to mention. Under the Age Discrimination and Employment Act, there are some timing considerations, both in terms of the employee thinking about deciding to sign, and then once they sign, they have an opportunity to change their mind. And under the Minnesota Human Rights Act, there is a comparable provision. So the ADEA was amended with the Older Workers Benefit Protection Act, and that requires that an individual has 21 days to think about whether or not they want to sign their release of claims. So you, as the employer, have to advise them of that. Under the Minnesota Human Rights Act, you just have to give them a reasonable time to consider it. And then once they sign it, they have 7 days under the ADEA to change their mind. And under the Minnesota Human Rights Act, they have 15 days to change their mind. So when you mirror that up with the 409A requirements that they can't mess with their ability of when they sign under 409A to drive when they get paid, you sort of have to look at the calendar to say, when can they sign, when do they have to think about it, and put all of those dates in the document very clearly so that the individual isn't controlling their own payment schedule to run afoul of 49A, but you're still complying with either the ADEA or the Minnesota Human Rights Act requirements. Now, I talked about the ADEA on the individual basis only. If there's a group termination and you're doing a sort of reduction in force and there's more than one person, 2 or more people technically, being terminated, the ADEA and the Older Worker Benefit Act works, those timing elements change. So it's 45 days to think about it, and then still 7 days afterwards. And you have to provide certain other additional information that they also get to look at during that 45-day period. So that's where you get, that's where you start to see fixed periods in certain documents and plans where we go up to 90 days, because we're sort of like, okay, in the longest possible world, we might have group reductions that this plan's going to apply to. We might be rolling those out in tranches. People might be thinking about it. So let's just put in our plan that someone's got to sign this within 90 days, and then we're within the 409A window, we're within the group RIF window, and we don't have to keep redoing our documents every time we do this. Large organizations that do a lot of Six Sigma reorganization and restructuring and have fixed plans find that to be a useful way of kind of setting their documents in stone and not having to recalculate and change dates all the time. But they're really just trying to match up all those different timing and document considerations. And I believe this is maybe our last slide. One more after this. Okay, great. I think we're doing okay time-wise, so that's good. So there's some other employment law issues. We were talking about some of the anti-discrimination stuff. You have to be able to provide, if you want to provide for alternative dispute resolution procedures, as Liz alluded to, you have to spell out that stuff is subject to the arbitration provisions. Anyone who's following the Supreme Court, you know that there's a variety of different agencies that are weighing in on whether or not folks can waive their rights to pursue statutory claims in front of a court, and whether you can make folks proceed to arbitration, and whether or not you can do that as a class, whether you can have class action waivers. But well-drafted arbitration provisions generally hold up for certain types of claims, so we encourage you to contact us because they mostly we think that they do the job, and we advise them when they're well drafted. But you can't contract out of the actual discrimination protection. So you can't say, the ADEA doesn't apply. The Title VII doesn't apply to you. You can't contract out of that. You can contract out of the resolution process in front of a court, but you've got to provide them with an alternative dispute resolution. You also have to allow the federal agency, as I mentioned, to be able to proceed with their aspect of it, and I talked about that a little bit. And I think I mentioned the ADEA, Older Worker Benefits Protection Act, with regard to the timing issues and the requirements for information statements in group situations. So, okay. So some final additional thoughts. Sometimes there's a variety of ways in which folks have been promised things all along the way. You've got your plan documents. If you've got a severance ERISA plan, you've got that document considered. You've got your offer letter. You might have incentive bonuses and commission plans and things like that might have promised things along the way. So you've got to check all of that when you're finally getting that one last document together.
And employment agreements.
And you've got your employment agreements if you've got that. So you might have an offer letter or you might have an employment agreement. You might even have both. If you are doing executive level employment agreements, that we've given you a sample paragraph there that we think is often a common one that we think does the trick and is fairly market in terms of making folks offering up some sort of promise of severance that doesn't comply with the ERISA. That's not part of an ERISA plan. And then the last sort of bullets are just kind of a recap of a lot of the stuff that Liz has already been talking about. One point, that first one, which is you want to think about reasonableness of severance if you are offering it in offer letters, and even if you're offering and considering adopting a plan, especially if you're a tax-exempt organization, you want to think about the reasonableness of what you're offering, because tax-exempt organizations are subject to reasonability with regard to their compensation compensation practices, so you want to think about that. If you are a public company, you got to think about whether or not you need to disclose this. If it's a standing plan, of course you do, and you're going to have to disclose it when you're about to let certain levels of executives go. So you got to think about timing and how that all works. I'll let you talk about the last two because they have tax code provisions in them.
Right. Well, Code Section 457 is a code section that applies to tax-exempt employers. And tax-exempt employers are not only subject to 409A, but also to 457, specifically 457F on deferred comp. And it turns its head sort of on when things, as soon as something is vested under 457F plan, it becomes taxable, regardless of whether you're paid or not. It's not like a 401k plan where you invest 20% a year and then you get paid out and taxed when you terminate employment and retire. So there were some new regulations proposed last year. They're not yet in final form, but if you are a tax-exempt employer, be very aware of that particular code section. And then 280G is a section of the Internal Revenue Code, has to do with parachute payments, extremely complicated. Not going to get into it there, but also worry about parachute payments.
Yep.
So I think we've ended on time.
I think that's it.
So thank you so much. Great.